Today's lecture is on role of human rights treaty monitoring bodies and protection of minority rights. Introduction. This lecture discusses various provisions of the treaty-based bodies which are of relevance for the protection of minority rights. Then it moves on to analyze the various treaty monitoring bodies about its structure and main functions. Treaty-based bodies. Treaty-based bodies are also known as UN legal instruments for promotion and protection of human rights. Human rights are universal. Therefore, members of minorities are entitled to all the rights set out in the different instruments. In other words, treaty-based bodies get their authority from UN human rights treaties. However, they can only address issues in states that have accepted the treaty. Equal enjoyment and non-discrimination clauses apply to all aspects of human rights, including civil, cultural, economic, political and social rights. Of the numerous legally binding UN human rights instruments or treaties, a few have minority-specific articles and all have rights that are of relevance to the minorities. There are 8 main UN treaties protecting a range of human rights. 1. International Covenant on Civil and Political Rights, ICCPR. 2. International Covenant on Economic, Social and Cultural Rights, ICESCR. 3. International Convention on the Elimination of all Forms of Racial Discrimination, ICERD. 4. Convention on the Elimination of all Forms of Discrimination against Women, CEDAW. 5. Convention against Torture, CAT. 6. Convention on the Rights of the Child, CRC. 7. International Convention on the Protection of the Rights of all Migrant Workers and Members of their Families, ICRMW. 8. International Convention on the Rights of Persons with Disabilities, CRPD. Another human rights treaty recently adopted by the UN General Assembly, the International Convention for the Protection of All Persons from Enforced Disappearance, is expected to enter into force shortly. Provisions in the International Covenant on Civil and Political Rights, ICCPR. ICCPR is a multilateral treaty adopted by the United Nations General Assembly on 16 December 1966 and in force from 23 March 1976. It is also the main legally binding provision on minorities in human rights law. Article 27 of the ICCPR specifically refers to minorities. It provides that persons belonging to minorities shall not be denied the right to enjoy their own culture, to profess and practice their own religion, or to use their own language. Other relevant articles in the ICCPR include the following: Article 2 on non-discrimination, Article 4 on non-derogation. Even in emergency situations, states may not discriminate against minorities by changing or abolishing those rights that are considered so fundamental, including the right to non-discrimination. Article 14 on equality before the courts and on language interpretation in criminal justice proceedings. Article 20 on the limitation of the freedom of speech if it constitutes advocacy of ethnic hatred. Article 25 on equal voting rights and equal access to public service. Article 26 on equality before the law. Provisions in the International Covenant on Economic, Social and Cultural Rights, ICESCR. The International Covenant on Economic, Social and Cultural Rights, ICESCR, is a multilateral treaty adopted by the United Nations General Assembly on 16 December 1966 and in force from 3rd January 1976. Provisions in the ICESCR which are of particular relevance to the minority rights are Article 2.1 on progressive realization of rights. This means that states must take steps to the maximum extent of their resources to gradually improve implementation of the rights. Backward steps are not permitted. Article 2.2 on non-discrimination, Article 7 on equality in the workplace, Article 11 on adequate standard of living, Article 12 on physical and mental health, Article 13 on the right to education, including human rights education and contribution of education to the promotion of understanding, tolerance and friendship among all nations and all racial, ethnic or religious groups. Article 15 on cultural life and the protection of the moral and material interests resulting from artistic production. Provisions in the International Convention on the Elimination of All Forms of Racial Discrimination, ICER. ICER is a third generation human rights instrument. The convention commits its members to the elimination of racial discrimination and the promotion of understanding among all races. However, religious minorities are not covered under this convention unless they are both a religious and ethnic or national minority. Similarly, linguistic minorities are only covered if they are also an ethnic or national minority. The convention was adopted and opened for signature by the United Nations General Assembly on 21st December 1965 and entered into force on 4th January 1969. As of April 2013, it has 87 signatories and 177 parties. Provisions which are of particular relevance to minorities are given below. Article 1.1 defines racial discrimination as any distinction, exclusion, restriction or preference based on race, color, descent or national or ethnic origin which has the purpose or effect of nullifying or impairing the recognition, enjoyment or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural or any other field of public life. Article 1.4 places an obligation on states to adopt special measures for the benefit of individuals and groups when necessary to overcome discriminatory patterns in the cultural, economic, social and other fields. Article 4 outlaws incitement to racial hatred and related practices. Article 5 lists a number of civil and political, economic, social and cultural rights that must be guaranteed without discrimination. Provisions in the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, is an international treaty adopted in 1979 by the United Nations General Assembly. Described as an international Bill of Rights for Women, it came into force on 3rd September 1981 and has been ratified by 188 states. Over 50 countries that have ratified the convention have done so subject to certain declarations, reservations and objections, including 38 countries who rejected the enforcement of Article 29, which addresses means of settlement for disputes concerning the interpretation or application of the convention. Articles in the CEDAW of relevance to minority women are as follows. Article 5 urges that states parties shall take all appropriate measures to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes or on stereotype roles for men and women. Article 7 deals with women's right to participate in public life. Article 10 states the required educational programs that eliminate stereotypes of the roles of men and women. Article 12 deals with eliminating discrimination against women in assessing health care. Article 14 deals with the situation of rural women, many of whom may be members of minorities. Article 16 deals with equality in marriage and the right to marry freely only with full and free consent. Provisions in the Convention on the Rights of the Child, CRC. The UN General Assembly adopted the Convention on the Rights of the Child and opened it for signature on 20th November 1989, the 30th anniversary of its Declaration of the Rights of the Child. It came into force on 2nd September 1990 after it was ratified by the required numbers of nations. Currently, 194 countries are party to it, including every member of the United Nations except Somalia, South Sudan and the United States. Article 30 guarantees rights of the children belonging to minorities. It uses similar wording to Article 27 of the ICCPR. Some of the other relevant articles for the minorities are: Article 7 deals with the right to a nationality. Article 17 encourages media to produce material from diverse sources taking into account the linguistic needs of the child who belong to a minority group. Article 20 deals with child's ethnic, religious, cultural and linguistic background when deciding on alternative care for a child outside the family. Article 29 deals with the fundamental purpose of education, including developing a child's respect for his or her own culture and that of other cultures, Treaty monitoring bodies. States are monitored to ensure they respect the treaty provisions to which they are bound. A state can be party to the different UN human rights treaties. In order to ensure that government is complying with the treaty provisions, the UN has put in place human rights monitoring committees, which are known as treaty monitoring bodies. A treaty monitoring body has been created for each of the 8 main UN human rights treaties. Human Rights Committee, Committee on Economic, Social and Cultural Rights, CESCR, Committee on the Elimination of Racial Discrimination, CERD, Committee on the Elimination of Discrimination Against Women, CEDAW, Committee Against Torture, CAT, Committee on the Rights of Child, CRC, Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families, CMW, Committee on the Right of Persons with Disabilities, CRPD. Structure of the monitoring bodies. Treaty monitoring bodies are made up of human rights experts from different countries. These experts are nominated by their governments, elected by states party to the treaties for fixed and renewable terms of 4 years, independent, that is, they do not represent the interests of their states. The number of independent experts in a committee ranges from 10 to 23. Its committee meets either 2 or 3 times a year, and the sessions last 3 to 4 weeks. Main functions of treaty monitoring bodies. The treaty bodies monitor how the treaties are being implemented by state parties. They perform a number of functions that can be grouped under 4 headings. 1. Reviewing state reports. This is a common function to all treaty monitoring bodies. State parties to human rights treaties are obliged to submit regular reports to the committees. In the state reports, governments are expected to list all legislative, administrative, judicial and other measures that they have taken for the promotion and protection of the rights provided for in the treaty, including minority rights. Treaty monitoring bodies are in charge of reviewing state reports. They identify both achievements and failings and make recommendations which the state should implement to ensure they are respecting their international obligations. 2. Interpreting the treaty. Treaties contain the human rights standards, but the treaty monitoring bodies provide important contributions to interpreting the standards and clarifying legal obligations. To do so, they issue general comments or general recommendations. Different treaty bodies have different names, but the purpose is the same. General comments are guidelines on specific aspects of the treaty. Minority specific example. The CCPR has issued a general comment on Article 27 of the ICCPR relating to minorities. It provides important guidance on how Article 27 should be interpreted by states. For example, it informs states that they may not deny the existence of minorities within their state in order to avoid implementing Article 27. It also reminds states that minorities do not have to be citizens of the state to benefit from Article 27. Other general comments contain guidelines for states of other provisions relating to minorities. For example, the CCPR has general comments on self-determination, freedom of religion, incitement to racial hatred, and equality before the law. CESCR has issued general comments on forced evictions, education, health and water. CERT has issued general recommendations on non-discrimination, incitement to racial hatred, gender and racial discrimination, descent-based discrimination, caste, and special measures. 3. Considering individual complaints. Some of the human rights treaty bodies have provisions for individuals to bring complaints called communications, alleging that their rights have been violated by a state party. States must agree to the treaty body receiving complaints from individuals within their state by becoming party to an optional protocol or explicitly agreeing to be bound by a provision in the treaty. Decisions on communications made by the committees are quasi-judicial, which means they are similar to legal judgments but not legally binding. States should implement this decision so that they comply with their international obligations. But if they fail to do so, there is little the committee can do. NGO pressure on the state is important to ensure decisions are implemented. The treaty bodies that may receive communications are the CCPR if the state has ratified Optional Protocol 1, CERT if the state has accepted to be bound by Article 14, CEDAW if the state has ratified the Optional Protocol, CESCR if the state has ratified the Optional Protocol, CAT if the state has accepted Article 22, CMW if the state has accepted Article 77, CRPD if the state has ratified the Optional Protocol. 4. Thematic general discussions. The treaty monitoring bodies can organize general discussion days on a particular theme or issue of concern. The objective is to promote a deeper understanding of the content and implications of the human rights treaties. These thematic discussions are public and open to NGOs. The outcome of the meetings can help the treaty body draft a new general comment to the treaty. Therefore, NGO participation is both constructive and encouraged. Conclusion. International legal instruments take the form of a treaty that binds the contracting states to the negotiated terms. When negotiations are completed, the text of a treaty is established as authentic and definitive and is signed by the representatives of states. A state can agree to be bound to a treaty in various ways. The most common are ratification or accession. The treaty enters into force or becomes valid when a predetermined number of states have ratified or acceded to the treaty. The binding treaties can be used to force governments to respect the treaty provisions. Thus, one of the criteria for the workability of treaty bodies and its associated monitoring bodies is the first instance for a state to enter into a contract treaty or ratify or accede to the treaty. While treaty-based bodies and monitoring bodies can be appreciated for the promotion and protection of minority rights, it is left to the countries to have different arrangements or even comply. Under such circumstances, NGOs play an important role. The openness of treaty monitoring bodies to NGO participation and contribution varies, but NGO involvement strengthens the work of the committees. The most important fact is that the work of the committee is unlikely to have a direct impact domestically without their involvement. Further, NGOs play a vital role in linking the international to the national and grassroots levels to ensure improvements in the lives of minorities. Thank you.